Thurston County Superior Court serves the county residents by helping them in the resolution of civil and criminal cases. The Superior Court guarantees a safe and easy access to court programs, making sure that all parties involved are heard. Today, we are talking to Superior Court Judge Eric Price to get a better understanding on what has changed in the court system under the Stay Home, Stay Healthy mandate. Thanks for joining us, Judge Price. How has your daily routine changed? Are you working remotely from home?
Well, I'm not currently working from home. We have definitely changed a lot of the schedules for the judges. You know, being the presiding judge here at Superior Court, I have a lot of administrative things. You can imagine all the changes we've had demand a lot of administrative time, and so at this point, I'm in the office for most of the day. Although there's a lot that I can do from home, and try to do as much as I can from home.
All right. What are the main changes that the Superior Court went through the pandemic?
Yeah, well, I really like the phrase "went through" because that's accurate, right? I mean, we, like all the agencies, we were really struggling with how to. We were struggling with incomplete information and trying to whittle down our operations. And for a while there, it was, the information was changing every day, and everybody was struggling with that change every day. And so we started back on, I think the date was March 13th, in which we made our initial decision to really clamp down a lot of the things we were doing here in the courthouse. We made that decision at that point to jettison a number of non-emergent things, but still did a lot of our criminal cases throughout the day, trying to make a decision of what was emergent, what wasn't. And then we tried to decide, well, obviously one of the big things we do here at the courthouse is have jury trials. So we were trying to be very sensitive to the notion that we were requiring citizens to come in and respond to their jury summonses. Didn't give them a choice on that. It was required. Meanwhile, you had an evolving amount of information coming from the press and from the governmental sources saying you shouldn't go outside, you should distance yourself. So, we had that pressure. And at the same time, we had the pressure of, constitutional rights to jury trials. We have a number of individuals who have, criminal defendants, some of whom are sitting in jail before trial. And how do you balance their rights with frankly, the rights of the community not to come in for their jury summonses? So way back in March 13th, we made a decision that we could probably have one jury trial at a time and still properly socially distance. We actually had a murder trial that was happening that same week, and we made a lot of adjustments to the jury that was sitting to try to distance them. We have very small jury deliberation rooms, where we changed that and had much bigger rooms for them. And even in the courtroom, we had them separated by 6 feet. So that was all going on on the 13th. Then, of course, the news kept changing. And so that next week in March, we came up with another order. I think it was the 17th, and said, at this point, we can't even have any jury trials. Mm-hmm. And so another emergency order came out on the 17th. So we cut out jury trials completely. And then on the 20th, we had to make yet another change. And so March 20th, we made the decision to try to limit the amount of time the courthouse was open, both with respect to public safety, but also with respect to staff safety and safety of the attorneys in the clerk's office. So on the 20th, we went through and made a decision to shut down half days at each of our two campuses. We have a family and juvenile court campus in which all of our juvenile matters and family matters are being heard. And then we have our main campus. And we are now currently open only in the mornings at our main campus, in which we're doing all of the hearings that we are doing here in the mornings. And then we're doing afternoons only at family and juvenile court. And that way we can kind of limit the number of security staff we have, limit the hours we're open, and so forth. So it's been a tremendously difficult process working with our stakeholders, the prosecutor's office, the public defense, the county commissioners, to try to figure out what we have to do, how we can do those things, and how we can do it in a way that limits exposure to the public, exposure to staff, exposure to attorneys on the one hand, and at the same time do what we can to not forget that we've got an awful lot of constitutional rights from litigants and victims and so forth. You know, this time has been challenging for everybody, but you know, public safety, you know, law enforcement is still operating, thank goodness, you know. So there still is law enforcement activity, and so long as we have law enforcement activity, we have to have some court operations that are occurring.
Now, are you doing any hearings like over webcam or telephone, virtually, or is it in
Yeah,
person?
yeah, no, that's a great question. One of the things we had to really look at is how can we do our hearings virtually, and let's set aside those things that are not emergent, and then once we have emergent things, how can we go about doing those with limited contact? Now, the other thing too that also operates in that overlays over this process is the public right to see what's happening in the courthouse. You know, we can't have a star chamber where we're doing things privately, shut our doors, and say we'll just do our business, and no one can see what we're doing. So we have that additional concern. So keeping the doors open to the courthouse so people can come in. You know, we don't recommend it, but if people can come in. So we've really tried to do more things by video, do more things by telephone. Our Supreme Court came out with an order that on March 20th that basically acknowledges that we have to do a lot more things by telephone. You know, maybe it's not optimal to do things by telephone. Maybe it's not optimal to do things by video, but to the extent we can, we are. And in fact, one of the few hearings that we are doing with defendants in the courtroom are change of pleas. Now, change of plea is when a defendant decides they want to plead guilty and not go to trial. That's a involved process to accept a plea of guilty. We currently don't have the ability to do that without the defendant in the courtroom, and we are working very hard to try to make that a possibility. In fact, just this afternoon, I have a meeting in which we're going to be testing a process through which we can have an exchange of electronic documents. That's one of the difficult things. You have, you know, if you have the prosecutor remotely, you have the defense counsel remotely, you have a defendant who's remote in the jail, and then you have the courtroom. How do you go about practically moving documents from one person to another, from the prosecutor to defense to the client so they can sign it, to the bench so the judge can sign it? All those are practical difficulties that we have with doing telephonic and phone hearings that we're really working through. And I'm been very proud of the cooperation we've had in the various branches and the various stakeholders of particularly the criminal justice system. In our county, we're lucky that we work well together, defense, prosecution, and the courts. There are some jurisdictions that are struggling with all the things that we're struggling with, and they don't have that good relationship. And so working collaboratively to try to figure out how we can change fundamentally the types of the way we conduct our hearings that we have to conduct, it's just so much easier in our county when we've got good relationships.
Yeah, so I'm assuming all jury trials have been postponed, put out to the future, right?
All jury trials have been postponed, right?
Mm-hmm.
And at this point, back on the 13th of March, at that point, we didn't have a stay-home order from the governor. We didn't have dates from the Supreme Court. We targeted May 15 as the expiration of our sort of modification of what we do. In other words, we decided back on March 13th that we would expect to hope to begin to normalize operations by May 18. Now, that was a guess at that time, and you've seen a variety of dates come from both the governor's office and some other sources, and that date is kind of sliding. It's moving a little bit. We can move that date up or back. My concern is maybe May 18 isn't going to be realistic. We don't know. I think we're going to be looking very closely over the next couple of weeks. I mean, you see sort of contradictory information coming from some sources about when we're going to be able to normalize. And we're going to be looking closely at that. But right now, we have no jury trials planned until May 18. And that, of course, is going to have a huge, just not doing jury trials for the length of time is a massive impact on the system. Just if you look only at April, not including the last couple of weeks of March, but only looking at April and the first 2 weeks of May, we've had to continue 280 jury trials. Now, we wouldn't be able to do 280 jury trials in any event, but those are the cases that were scheduled during that time period that have all had to be moved. So when the lights come back on, we're going to have a crushing volume of trials to have to try to get to. But you're right, we're not doing any jury trials. Again, you're balancing the difficulties of bringing people in the courthouse, the impossibility of having appropriate distancing on the one hand versus the right to trials on the other. It's a very complicated, difficult thing to go through. But at this point, the decision is no jury trials until May 18.
Is there any possibility that jury trials could take place virtually over webcam? Have you thought about that?
Well, yeah, we've thought about a number of things. I think if this looks like it's going to go beyond that, and of course, what things look like when we know what is normal going to be. You can imagine a situation where, once and I use the phrase, once the lights go on, we're probably not going to be able to socially distance and normally we can do a maximum of 3 or 4 trials at a time, just because of courtroom space and so forth. We're not going to be able to socially distance jurors to do that many trials, probably when we do go live. So, we might start with 1 trial or 1 or 2 trials. How do you go about actually doing jury trials virtually? It's hard to get your head around that. I'll be honest with you. Part of jury trials is having someone sit in a witness stand 12 feet from 12 people and them looking at that person, the way their body moves, the way their eyes look, and making judgments about whether they're telling the truth or not. That's fundamental to a jury trial. And to be able to do that virtually would be a challenge. Maybe we'll end up there. I'd like to, I hope not, because again, the fairness of that trial it's hard to imagine.
Well, how can people get information about their court dates? Is it through the website? Do they you have a phone number where people can call?
Yeah, well, that's a good question because a number of, we do civil work, we do criminal work, and then we have family and juvenile court. If there's folks that have a criminal case, for example, all we're doing now are criminal cases regarding people in custody. So if you're in custody, we are processing those cases. If you're out of custody, meaning you've been accused of a crime, you have a series of court dates, we've kicked all of those outside this window past May into June and July. And those deadlines are further out than they used to be. If folks are confused about those deadlines, and I can understand how that would happen, they need to talk to their attorneys. Most of, if not all, I count on one hand how many of those hundreds of defendants don't have a lawyer. They need to be in contact with their attorneys, and their attorneys can then access that information for them. For some of our civil calendars, again, if you have an attorney, you should talk to them. That's the first step that I would say to anybody who has business with the court. Other than that, there is information on the clerk's website about their cases, if they know their case numbers. And that's an important distinction. With respect to Superior Court, we have a separately elected court clerk, and they have their own clerk's webpage. That's different from Superior Court. And the clerk has the information about their cases, and they can access the dates and when things have moved. We still have, and I should point this out, notwithstanding the fact we've pushed out all out of custody criminal matters and we've stopped doing all civil matters, we still have avenues for emergency matters to be heard. And we call those ex parte matters. And there is a way to get into court, and that's on our webpage. So I really encourage folks to look at the Superior Court webpage to get the most updated information on how to go about getting into court if you otherwise are, if you feel like you have an emergency or if your attorney does.
Now, I know there's an effort to keep the jail population down and maybe even release some low offenders. Are you offering different plea bargains, fees, community service, and are you releasing people from jail?
Well, whether things are offered would be a better question for the prosecutor. You know, um, it's their role to make a decision on how they want to make offers to resolve cases. But there has been a real effort to get nonviolent offenders out of the jail. You know, the word that's one of our the head of public defense calls the jail a cruise ship, where everybody's new people are getting on every day. And there's a real concern about having unnecessary people in jail. And there has been a process where the prosecutor and the defense have come together and looked at the folks who were in jail and agreed to a certain number of those folks who could be out without jeopardizing public safety. And so there's been an effort. You know, that people are pre-trial can be in jail for a number of reasons. One, because there's a very violent, you know, public safety risk, and the other is because they haven't come to their court dates. For the most part, folks, well, there's been a lot of effort to release the nonviolent offenders, and then to just move their cases to after we're done with this. So that process has happened. And then there's been, even if there hasn't been agreement from the prosecutor, there's been a number of motions that have been brought to have people who otherwise were in jail on a certain amount of bail released. And the court has entertained those motions as they are argued. Even if they're not agreed to, the court has heard a number of those. And we've seen that. We've seen a big volume of motions brought by defense counsel to say, my client should be out, prosecutor might disagree, and the court makes a decision. I don't have the jail numbers offhand with me, but I know that the jail numbers are far lower now through this process of trying to get people out. We've been very, I'd say the prosecutor and defense, as well as the court, have been very active in trying to entertain those motions.
Okay. Well, we're going to let you go, but is there anything else you'd like to add before we do?
No, I guess I would just add this. You know, the thing about the justice system, both the civil and criminal, is it's sort of like the fire department. You don't really want to need them, but if you really need them, you have to have them. And we are aware that even though we have made some difficult decisions about what's emergent, what we have to hear, there's an awful lot of damage that happens just from not hearing all those matters that that would otherwise be characterized as non-emergent. For example, if let's say you have a car accident and you have a trial coming up, well, that's a civil trial. You may not have that trial because it's not considered emergent. That doesn't mean that we don't recognize here in the court that that's still a cost, and that still hurts, and that's still hard on people to have all of those things delayed. And even though we're all making decisions that we have to make, there's an awful lot of litigants who otherwise would be accessing the court every day, not only civil litigants, but victims and defendants, you know, a lot of whom the closure in and of itself of having a case resolved is a benefit to them. And we know that's not happening, and that's hard for a lot of people, and we know that. So I want to make sure that folks recognize as we make these difficult decisions that we are also very cognizant of the hurt that it causes for folks not to have open access to the courts.
All right. Well, thank you for your time today, and thanks for what you do to keep us safe.
All right. Thank you very much. I appreciate the opportunity to talk with you.
For more information on the changes to the Superior Court operations, go to www.thurstoncountywa.gov/SC. To find out more about the postponement of proceedings, visit the county clerk's website at www.thurstoncountywa.gov/clerk. That's all we have for you today. Tune in next time for more updates. Again, if you have any questions or suggestions for something we should cover, send an email to rkam@tcmedia.org. Stay home, stay updated with Thurston Community Media, and stay safe, Thurston County.